Good evening, everyone. Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are here today with the attorney Prashanthi Reddy to discuss the latest updates on immigration, latest most awaited October visa bulletin, immigration updates, and frequently asked questions. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We'll start taking calls in 10-15 minutes, so please keep calling. I would like to repeat the disclaimer before we start. Please note that the show is not intended to provide any legal advice and it is very general in nature. It is only for informational purposes. Sakshi TV News and agents are not responsible in any way for your actions. Please use the information at your own risk. Hi Prashanti garu, how are you?
Hello, Andy.
So yeah, it's hot topic now. Most people are discussing about the most awaited October visa bulletin. So let's start with that. And see, because of the family-based spillover, looks like there is an opportunity for a great movement in EB categories for a lot of countries, especially India. So what's your take on that?
Yeah, so that is correct. Because of this pandemic, what has happened is because of the presidential proclamations not allowing family-based green card holders to process their cases abroad, and also because of non-availability of flights, so many factors. Family-based petitions have been affected, so very few have been filed this year. As opposed to that, employment-based petitions have been filed. There has not been any downturn in that. That's because with reference to employment-based green cards, they're mostly already here in the country. So the processing has continued. But for family-based cases, they're mostly outside the country. Traditionally, family-based cases, I-130s are usually outside the country. Or they have to come into the country and then they file. So that hasn't happened this year. The families have not been able to plan and bring their parents, usually like they do on a visitor's visa, and then wait and then file for adjustment of status. Because of COVID, everything is at a standstill. Also, people filing directly for green card spouses. U.S. citizen spouses are not affected, and U.S. citizen parents are not affected. But again, since they cannot travel, and because the consulates are closed, processing has not happened, and so there's been widely a standstill in family-based petitions. And because of that, every year in October, the spillover from the family-based preferences, if there's any spillover, any extra visas, it goes into the employment-based category. And so this October is the start of the fiscal year, and that's when it usually happens. We are thinking that there'll be a significant spillover from the family-based to employment-based. So there should be significant movement. EB1 might become current worldwide. EB2 might, EB3, EB2 might become current worldwide also. But we're not expecting India to become current for EB2 and EB3, but there will be a significant forward movement, maybe a few years. It's difficult to say, but pretty much this has been the second largest influx of visas for the month of October. That's what's expected in the whole recent history of the Department of State. So recently when, Charlie Oppenheim is the person who's responsible for allocating the visas at the Department of State, and he anticipated that there'll be an infusion of about maybe 250,000 immigrant visas from the family immigration visas. So that's a significant amount. So just to put that into perspective, the largest allocation for visas at one time was 158,000 for employment based. This is the second highest. It's 156,000. So that's a reflection. That's a basically 63% increase of visas. So that's pretty significant. But also what we have to remember is that there's also now diminished processing capacity. So it's not all good news. Even if it's good news, there's some bad news. So there's diminished processing capacity with the USCIS and at the consulate level. And therefore, they're expecting that, USCIS will not. So there's two dates, final action date and processing date. So they're expecting that even though visas are available, USCIS will not allow as many visas as are available because they don't have the capacity to process it. So there might be some curtailing with reference to that. So you might not see all the visas, flooding in, all the visa numbers. So because of that, that can affect, dampen kind of the influx of available visa numbers. So that's kind of a dampener. But still, I think there is significant movement. So we expect, as I said, significant. How significant, we have to wait and see. We don't have a crystal ball, so we don't know that exactly. But definitely something to be excited about and something to look forward to, and the visa bulletin might come out anytime. The next few days, we were expecting it already. It's already delayed. By the 15th, it usually comes out. But there's obviously some competing factors that, due to which it is getting delayed. Most probably politics is playing a part here. And again, the diminished capacity of USCIS because they have furloughed a lot of, though they have not furloughed employees, though they said they would furlough 70% of their employees, they have not. But what has happened is they have furloughed a lot of independent contractors. And independent contractors are the people who actually process these cases at NBC. So all the family-based cases get processed there. And also at the regional offices, at the local service centers, you have independent contractors, and then production of documents. And so there's a lot of work that they do behind the scenes. So that furlough of independent contractors is definitely, we're going to take a beating with reference to that. So, that's what it is. I think for now, we have to wait and see.
Now that there is an expected movement in the employment-based categories, we probably have to talk, how to file an I-485 and what documents have to be kept ready if, someone's date becomes current and, let's say if EB2 is not current, but EB3 becomes current for them, for someone, and, how to downgrade it. Could you please explain about it, on how to be ready for everything?
Right. So first thing we have to keep in mind, Ranjit, right, is the increase in fee, right? As we were discussing off the show. October 2nd, the fee is increasing. So there's nothing much we can do about it, but there's a significant increase in the 485 fees. So please keep that in your budget because now there's a separate fee. The 485 fee actually has marginally decreased by a few, so basically, as I was saying, there's going to be an increase in fee, so you have to budget that out. The 485 fee has actually decreased slightly, but before, when you filed your advance parole and your EAD, employment authorization document, with the 485, there was no fee for it. Now they're charging a separate fee for that, and that amounts to about slightly less than $1,000 extra on the 485. So that's a huge increase in the 485 processing fee for the total package. But there's not much we can do about it other than prepare. But the other thing is there is a lawsuit on that fee increase. So hopefully it'll be a timely decision, and hopefully it'll be in our favor, and they will disallow the increase in fee. But let's see what happens. The second thing to remember with reference to filing of the green cards is the public charge rule has come back very recently, because it's been a roller coaster up and down. They've taken it out. They first implemented it in February, then they removed it in June, and then in July, I think. And then again in September, recently, they've There was another court ruling which said that the public charge rule should continue until there's a final court decision. Earlier, there was an injunction, and another court granted an injunction to put a hold on it. Then now, another court has said that, yeah. So basically, I was talking about the public charge rule. So that's something that has come back again. So processing of a 485 is more time consuming now, and more documents have to be submitted. Again, we're hopeful that the final ruling will come from the court and we don't have to submit this additional document and supporting documents. But for now, yes, public charge rule is very much in place, so the new forms have to be submitted. And in addition to the forms, you also have to submit, your health insurance plan to show that, you will not be a burden on the health insurance system. You have to show maybe your degrees to show that you're, employable, you're qualified. Of course, your tax returns, bank statements, and then you have to make sure that you can support not only yourself but your family, whoever is filing for the application. And also, you have to show that if you're already supporting somebody, then you have to add that person also into the calculation. So it's not a very high amount, but for people who don't have a job or who have maybe a part-time job or are students, it might
sorry to bother you again. Looks
Yes,
like the
Ranjit.
caller is on again. Let's
Sure.
take the call. Hi, welcome to the show. Please state your name and ask your question.
Hey, my name is Raj, and hi Prashanti Garu. Hi Ranjit. Yeah, hi. Company called us, and I don't want to reveal the company's name. I have a couple of questions. First thing is, we have an employee, but we terminated them, but they have a new project. So when we open an LCA, do we mention as a new employment or continuation of or change in previously accrued employment?
So if the person is not on your payroll and you're filing a new petition, then what is his status, is the question.
No, because of the 60 days grace period,
Okay.
we just terminated
So you're
her.
filing during the 60 days grace period.
Yeah, but she was an employee in the past, and we terminated her on September 1st, and now we are filing her on a new project. So I just wanted to see, do we mention continuation of change in previously accrued employment or new employment on the LCA?
You should just mention it as new employment because there was a break, and plus also you're not filing an extension. So you're refiling did you withdraw the previous H1?
Yes.
Okay, so then definitely you have to answer it as new H1, new employment.
Okay, thank you. And one more question, Andu. I see the consulate have been opened and in India, and also there are dates for February and March. Can H1B employees who are in India can book the slots?
Yeah, so it depends. If they were in India at the time that the proclamation was announced, and if it is, then they cannot, unless it is an extension without change.
Only till December 31st, and they're told they'll notify, but we don't have any notification yet.
Right. Of course, I'm just presuming. Yeah, I mean, and also the elections are coming. So if the present administration continues, we're expecting them to extend it until next year, at least until March, April, until this whole vaccine comes in or something happens. But if the elections result in present administration being removed, then it's possible that all the executive orders, will go away. So yeah, there's no harm in booking the slot, if they're able to. Also, you have to remember that there's so many exceptions with reference to who can apply. So most people can apply for a H1 as an exception. And we can, talk about that further because there's so many exceptions. And, for sure, I can tell you that, your employee will fall within one of those exceptions. And we can, discuss that further. But yeah, as of now, I think you can apply for an interview date and then see what happens. If it is not lifted, then try to be in one of the exceptions. But of course, you have to write a memo and send it to your employee, and they have to submit that memo as to how they fall under an exception.
Okay, I think we can continue with our discussion. So one question that is the fees is going to be increased, but then let's say I mean, I know there is a lawsuit that's pending. So if the lawsuit result doesn't come, the fees automatically would change, and if there is an injection, only then the previous fees applies, right?
Yes, only if there's a temporary injunction stopping it, if the court grants it, then they could immediately stop that increase in fee while the court case, goes on. But otherwise, we'll have to wait until the decision.
Same applies to the public charge rule as well, right?
Yeah, absolutely, yes. A public charge rule, in fact, Ranjit, as I was saying, they did grant an injunction, and then another court said that, the injunction is invalid and it should continue. So that's what happened. It's been, kind of up and down. But as you were saying, with reference to, so these are the two things we have to keep in mind with reference to processing. Also, most importantly, you have to know what documents you need to gather, right, in order to file the 485. This is very important. So most people you'll have your passport and your I-94. You'll have your degree certificates. You'll have your pay stubs to show status, your H-1B approval to show status. But what you need to get most probably would be your medicals. So you need to go get medicals done. And I would invest in medicals even if the visa bulletin hasn't come out yet, because it's a matter of money expense, of course, but as long as you're able to bear that, then you should get your medicals done. And also make sure you have your birth certificate. This is very important for a 485. You have to show that you have a birth certificate. You have to show that your birth was registered at the time of the birth. If it's a late registration, meaning if you just got it registered or you registered it 10, 20 years after your birth, then you also need to submit secondary evidence. Secondary evidence of birth, which means basically earliest available evidence of birth would be what they consider to be a transfer certificate or a school leaving certificate, which mentions your name, date of birth, and your parents.
Sorry to interrupt you, Prashanti. We have a caller, Kaushik. Let's take the call and then continue the discussion. Hi, Kaushik. Welcome to the show. Please ask your question.
Hey, yeah, sure. Good evening, madam. So I have one question. So because of my wife's biometric was scheduled on March 24th. So in that time, the USCIS office closed. So we are waiting for rescheduled appointment. Still, we didn't get it. It's more than 250 days. So is there a legal status issue, or do we have to leave the country? Can you explain about this situation?
Right. So it's been, we are seeing that especially H4s who have not been got their biometrics, it's taking 8 months, 5 to 8 months for them to process it. And with the ASC, so application support centers closed, there's no way of them getting your biometrics. And so, there's nothing they can do or you can do to, unless the law changes completely and they say biometrics are not needed anymore. They have given one concession. They have said that if it's an extension of the H4 and the biometrics have been done in the past, then they will accept those biometrics. But if they haven't, if the biometrics are not done, then, I would have suggested that of course, you will be following up. You will contact your local congressman. You'll contact the USCIS. You should contact the ombudsman's office. And if all this fails, a mandamus petition might be a way out. This is basically you're filing this in district court. It's a right that you have. So when you're asking the government to do something and there's some benefit that is due to you, you can request the government to, force the government to rather, process it in a reasonable period of time, process the benefit. And if they have not done it, you file that mandamus claim. But in your wife's situation, the problem is that biometrics have not been done and the law requires that it be done. So, your mandamus claim may not be as successful. But with reference to whether she can stay, of course she can stay in the country. As long as she filed while she was in status, her status is not jeopardized in any way. Of course, if she has an EAD and if it expires, then she cannot work. She'll have to, they'll have to remove her from the job, and then once she gets the EAD, she can join back. You can also ask for an expedited request if there are some special circumstances, but I think everyone at this point has special circumstances, so I don't know how successful that really will be.
For my bail box and checking, it's a lot of disappointment. Yep. Thank you.
Right,
Thanks
right.
for your.
A lot of people, unfortunately, are going through the same situation. But yeah, it seems to be the only. Other than constantly following up, the only other option might be that mandamus claim.
Okay, I think we answered the question. Okay, let's go back to about the filing. We were talking about medicals. So other question we have is, how long are the medicals valid? Let's say if someone has done medicals today and kept it ready, and by the time USCIS adjudicates the application, let's say it's like 8 or 9 months from now, will they still be valid, or will they request another one?
So usually they say the medicals are valid for a year, but what happens is, you have to remember this, Ranjit. Everybody who's filing the 485 now will most probably not get a green card, because not only should they file, but when the processing is done, by the time the processing is finalized, the visa number should still be available. So what will happen is, a lot of people will go into the pipeline, and there'll be a 485 pending for them. So they have, that's a big relief, because then you don't have to depend on your H1. So you can use advanced parole and EAD for years and continue, and you're not dependent on staying with any one employer. You can have your own business. There's so much more that you can do if you have a pending 485. So that's a boon or gift in itself. But I don't think the visa numbers are going to be available for long enough for them to actually get the green card. So for sure, they will have to get the medicals done again when the visa number actually becomes available. And people get an RFE, and in that request for further evidence, that's the thing that they usually ask for. They ask for medicals, and if there are any other issues, then they might ask for that. Like I was saying with the birth certificate, if there are any issues, or if you don't provide secondary evidence, or if the birth certificate is not available, if it is never registered, just coming back to the birth certificate issue, you have to have a non-availability certificate. So that's also important, something to keep in mind and to get ahead of time, the non-availability certificate, because you will get an RFE if you don't submit these documents.
Sorry to interrupt you, Prashanti. We have a caller, Srinivas, on the line. Now let's take the call and then we'll continue. Hi, sure. Srinivas. Welcome to the show. Please ask your question.
Okay. Hi, Ranjit, and hi, madam. How are you?
Hi. How are you?
I'm good, thank you. I have a couple of questions regarding that visa bulletin dates. The chart is always, it's like a big dilemma. I came to US in 2006, and my employer filed my green card in the year of 2010. So, firstly, like in 2012, dates were moved to May 2010. So then after that, it went back. So now in the year, we are in 2020 now, so still the dates are same. Everybody says that there is a porting from EB3 to EB2. So in that case, EB3 should move ahead, but it never moved. So that's the one question. And regarding that birth certificate, I don't have any birth certificate. But I do have affidavits from my parents. So is that valid?
Yeah. So first, to answer your first question, which is a very good question, because we were going to talk about that later on. But the porting of so a lot of people are expecting, we're expecting that EB3 will move a little faster than EB2. In general, we've seen that just because there is more demand. It's all demand and supply. There is more demand for EB2 because most people who are filing green cards are really master's degree holders, or they have, at least 5 years of experience and a bachelor's. But also we have seen that because of this knowledge that EB3 is moving faster, a lot of people have downgraded to EB3. So that has again kind of stopped the possible movement, because then everybody downgrades to EB3, then that's, then there's going to be a demand for EB3. So it's difficult to kind of, as I was saying earlier, we don't have a crystal ball, so we can't see what will actually happen. And I'm sure, there's a lot of manipulation going on in the background. There's so many competing forces, right, with this visa bulletin. So, and there is no clarity and there's no transparency really. I mean, so there's who's to question, what the visa bulletin finally says. So keeping that in mind, I would say wait for the visa bulletin to come out. And if you see that you will be, EB3 is current for you, then what you should do is then immediately file an I-140 and 485 concurrently, for EB3. So file an EB3 I-140 and then file the 485, file both together. That's completely possible. But it's just, again, documents needed for I-140, you have to make sure you have. That's all mostly employer-related documents. You have to talk to them and make sure they're willing to do it, firstly. And, we need the employer's tax returns, of course, all your degree copies, your experience letters as per the labor cert. So since you've done the I-140 earlier, you should have most of these documents, except for the employer tax returns, because those you need the latest ones. And the other documents like the, what I was mentioning for the 485. But with reference to your second question, the birth certificate, most people born after 1982 should have a birth certificate. So they expect you to have one, and if you don't have one, then they expect you to have a non-availability certificate in hand. And if you, so you will for sure get an RFE. So you should try to get that non-availability certificate and submit that along with the affidavits that you have.
Okay, madam. Is there any expiration date on it? Because of, I took those in the year of 2015, so I can still submit those documents, right?
Which documents are dated 2015?
Non-availability and affidavit.
Oh, yeah. If you already have non-availability, I didn't realize you do. Yes, doesn't matter when it's dated.
I do, yeah, okay.
Yeah, you can use it. And the secondary evidence is the affidavits. I would also keep my school leaving certificates as well, because they might ask for those as well. So just keep that also ready. Your transfer, it's called a transfer certificate. So keep that as well.
So so we are discussing about the documentation for I-485, what to keep ready. So so what else we have to keep in mind? So we are prepared when the time comes. So the medical's validity is 12 months, you said, right?
Correct.
So what else do we have to keep in mind?
So because of this public charge rule, we should also make sure we have some kind of health insurance, because they will ask for that. And that's a plus if you show health insurance. Then they know for sure that you will not be a public charge. If you don't submit health insurance, and they'll look at the totality of the situation, they look at all the documents you submitted, and they will see if you're likely to become a public charge in the future. But if you're working and you have a steady job and you worked for several years, so that might not be an issue. But in general, it's prudent to have health insurance as well. Most of you, if you're working, will have this through your employer, so you just have to keep that ready. In addition to that, some people don't have their I-94s because nowadays I-94s are not given at the port of entry. Instead, you have to go log in to the website, go to the USCIS site online and get your I-94. So make sure that it's available online. Sometimes, we're surprised that an I-94 is not available online, so make sure that doesn't happen, because that's really what determines your status. You make sure you have your H-1B approvals, including the I-94 attached at the bottom, from your employer. At least you have a copy, because that also determines your status. And for a 485, you have to show that as of the date of filing, you're in status. Also, if you're filing for family members, make sure you have proof of relationship documents. So basically, for your spouse, you would need a marriage certificate. If you're filing for your spouse, if you're filing for your children, you would need birth certificates. So that is required, and all these documents are required for each family member. It's not just the principal applicant that has to submit these documents. Every single family member has to submit the same documents, and the fees that we were talking about applies to each applicant. So, it's a big chunk of money that you will be donating to the USCIS, so make sure you're prepared.
And other question, we were talking about is what happens, let's say EB2 has moved until 2010 and EB3 moved until 2011, let's assume. We don't know yet. So let's say mine is EB2, but EB3 has moved forward and I probably would be eligible for EB3. Then, how do we proceed? How do they downgrade it? What do you suggest?
So for sure, as I said, getting into this window has huge benefits. Filing a 485 has a huge benefit, even if you don't get the green card for the next 10 years. But just filing it is such a relief. You will be away. You don't have to deal with all this H-1B issues that, with amendments, whenever you move, with extensions, RFEs, you can work for any employer. So there's much more independence when you file a 485. So I would definitely say if the whatever is available, you should definitely file an amended I-140. It's called an amended petition. It's pretty much like a regular I-140 that you're filing. Only thing is, you're on the form, you're saying that you're amending and you're downgrading to EB3. And, you don't have the original labor cert with you, obviously, because that's already with the USCIS. So you have to inform them that, don't say that, don't just submit a copy without actually marking the right column in the I-140, which basically says that, the records are with them. So mark the right columns. And then you have to prove that you qualify again for EB3. The prevailing wage is going to be the same, even though, whatever was on the labor cert will be the same prevailing wage. So again, you have to show that your employer has the ability to pay from the date of filing the labor cert to present. So if your company is not doing well or files losses in their tax returns for various reasons, and if your salary is not, you're not getting paid as much as the prevailing wage, then you might not be able to file. You can file an I-140, but it might not be approved. So that's something to keep in mind. What the employer's tax return looks like and what the difference is between the prevailing wage on your labor cert and the wage that you're being paid on your W-2. And if the employer can show the difference in wage via their, the profits in their tax return. So that is another thing, the ability to pay, it's called. So that issue is something important to look at when you're even amending your I-140. It's like a new petition. And of course, then you would need all the experience letters, and you have to show that you have those skills. Whatever is mentioned in the labor cert as any special requirements, you have to prove that. And then, of course, your pay stubs, degree copies, and your passport, you have to be in status. You have to show proof of status. So, so it's quite a time-consuming application, the I-140, but it's, not hard to do. So as long as you meet all the requirements.
Okay. Another question is, what happens when, let's say my date became current, but then it was with an old employer, but my employer is still in the process of having the I-140, in the filing. So what do someone has to do if they are in that situation?
Right. So that's a tough situation to be in because we want to file the 485 and you can't file the 485 using your old employer's I-140. So you either have to go back to that employer. So that's another thing to keep in mind. If you have not filed and if you have an old I-140, I don't know why you would do that because people usually, as soon as they move, they file in your I-140 because you never know what happens with the priority dates. So in that situation, you'll just have to go back to your old employer and ask them to file. You don't have to be on their H1, remember, to file adjustment of status. This is a future job offer. So if they're willing to file and if they're willing to attest that this permanent job offer is still available and that if they're willing to hire you, once you get your green card or once you get your EAD, you can still go back to them and have them file this for you. So that's some legwork to do, right? Which is a good question, Ranjit. So that's additional legwork for you to contact your old employer. I don't know what, you may or may not be on good terms with them. So that's something to look into as well.
Let's say if I have to go back to the old employer, but then they have already withdrawn the I-140, what happens then? So do they still can file I-485, or because they have already withdrawn, they cannot do that?
Yeah, unfortunately, that's another paradigm. Most employers do withdraw their I-140s once once you have left, but some don't. So yeah, you're out of luck. If you have withdrawn the I-140, then there's no way you can use that to file a 485, unfortunately. So you should have an active I-140 in order to file the 485.
So have to make sure that it was not withdrawn. Only then that's the only way we can use the priority date current, or just wait until I-140 is approved from current employer. But then you never know. By the time sometimes the dates retrogress. So
yeah, most probably they will. So if you have an I-140 right now, that's another thing to do. We're getting new steps for you to take, new homework as we're discussing. The I-140 should immediately be converted to premium processing so that you get it on time. So yeah, that's another very important thing to do. Convert all the whatever I-140s you have to premium processing.
True. And other thing we have to keep in mind is from October 2nd, the premium process timeline will be changed. Instead of 15 calendar days, it will be 15 business days. That means it won't include holidays, it won't include weekends.
Almost 20 days then. It's almost 20 days. It's no longer.
Yeah, again, it depends on when it is filed. So yeah, that's one thing you have to keep in mind. Yeah, other question a lot of people have is, let's say someone, don't want to go through all these H1B hassle and left US. Now the date becomes current. So what can they do if the employer has not withdrawn the I-140 and is still willing to sponsor? So can they go through the consular process or come into the country on some visa and do it? What options do they have?
Right. So that's also a good question. So one thing is, if the I-140 was approved for consular processing, then automatically NVC, National Visa Center, will send you an email that your date is current. And they will, then the processing will start. They will send you everything by email.
I mean to say, I-140 was approved when he was in country, but then he left the country because of all these H1B hassle.
So even when you filed, even when you filed the I-140, it could be that they filed it for consular processing. It could be that they filed it, it doesn't mean that if they're here, they cannot file it for consular processing. So whatever the situation might be, if it's consular processing, then NVC will send an email as soon as the date is current, and then you have to follow the process. Everything is filed online. All the documents are gathered. It's like a 485, but it's an immigrant visa. But the documents are the same as what we discussed. Once NVC gathers all the documents and they're satisfied, then they will send the documents to the consulate abroad. But unfortunately, the visa number has to be available when the consulate is looking at it. So there's not much benefit because you're not filing a 485. So it's not like a pending status. So if the dates retrogress while everything is still pending with the consulate or is pending with NVC, then you're pretty much out of luck, because they'll put it on hold either at the consulate or at NVC, and then they will notify you again once the dates become current again. The other thing you could do is, see, coming on a visitor's visa is not possible because you have an I-140, an immigrant petition file. Unless you have a visitor's visa from earlier, and then nobody asked you any question at the consulate as to your intent. Coming on F1 is a problem. So it's the same. All these statuses have intent questions. So you can't really, you might be able to enter if no one asked you anything, but if you have to apply for a new visa, definitely they will not grant you the visa. You can come on a H1 possibly, but that has its own challenges, right? Because the H1 has to get approved. So maybe that's another thing to do. File the H1 now in premium processing. But again, that's also difficult because, consulates are closed. So it might be too much. Those people might be out of luck, those people who are outside the country, unless they're able to come back somehow and then, file for adjustment.
Yeah, the best option would be, as you suggested, file an H1B and come on H1B, and anyways, when you are on H1B, you can do
Right.
I-485 filing.
But you have to have enough time to do that, which is, we don't know.
Yeah.
But something to look into for sure.
Yeah, sure. Because H1B doesn't take long if it's in premium and everything is in place, probably LCA would take a week and then another 2 weeks. So it's
Yeah, but the thing is, they also have to go to the consulate, right, Ranjit? So that's a different story.
That's always there. Yeah.
Right.
Yeah. But at least that's something you can keep in mind.
Right.
Someone can keep in mind, and try all the possible avenues at least. So yeah, we have other couple of questions here. One is, okay, what happens when someone leaves the country when perm is pending, and what happens when someone leaves the country when I-140 is pending? Does it impact the processing in any way, or it really doesn't matter?
So are they leaving the country permanently, or they're leaving on vacation?
No, yeah, just for an emergency, let's assume.
No, it doesn't matter. It doesn't affect the process at all. So labor cert or I-140, it doesn't affect the process. I know a lot of people somehow think that, once you file this, you shouldn't leave, or once
Yes.
That is applicable to 485.
Okay.
In certain circumstances, and for citizenship cases in certain circumstances.
Okay.
But not if you file while you're filing the PERM or the I-140.
So, okay, so even, you can file an I-140 or PERM when someone is out of country, or, let's say when someone left while PERM is pending, and, when he was out of country, it's approved, and then they can also file I-140.
Yes.
So yeah, it has no relevance to be in the country, because
you can file if you're not in the country, you file I-140 consular processing. And then you can always come into the country and adjust. There's nothing stopping you from filing adjustment of status, even if you file consular processing.
Yeah, at least, yeah. And anyways, I-140, I mean, the GC is a future employment, so it doesn't really matter until the date becomes current.
Right, I guess that's the logic.
Okay, other question we have is, does the latest amendment overrides the extension approval validity? Let's say I have an extension until 2 years, but then there was an amendment made because of any reason, might be there is a change in job duties or change in client location or job location, or for any reason. When I applied an amendment, I got it only for, let's say, 6 months or a year, but my extension is valid for 2 or 3 years. So what happens in this situation? The latest approval will take over, or because you have an extension, how does it really work?
So this goes with the last action rule. Basically, so whatever action that is taken last, it's not about when it is approved, but it is about when it is filed. So if you file the extension after the amendment, the extension will take precedence. But usually what we recommend is that if you have an amendment pending, and if the extension is coming up, then I would just file an amendment cum extension. in this for the second petition, so that even if the first petition gets denied, you get another bite at the apple, and your case is looked at again for the amendment as well. So we just file amendment come extension, because the amendment is taking so long, and sometimes not always is premium processing available. And then we can always, if there is an RFE on the amendment, we can always say that we have filed another case, and therefore we don't wish it's not necessary to respond to this. It's up to the employer what they do. But yeah, whatever is filed later, that is what takes precedence. And if you're filing an extension, if you have an amendment pending, I would just do an extension amendment to ask for both release.
Yeah, the case I'm here talking about is extension is already approved. It's valid for 3 years.
Okay.
And an amendment is just filed because of some change. And amendment only got approved for 1 year, let's assume. So what happens? Because extension
so then unfortunately you're losing that 3 years. You only get, if you're only getting 1 year, then that is your approval. So you have to file an extension again after 1 year. But thankfully, recently they've been approving cases for 3 years. So in the past, as you said, that was a huge problem. And there was no way of knowing that they would only approve it for 1 year. So that was a huge problem. But now maybe we won't see that issue as much, because they are approving for 3 years, unless for some reason, concrete reason, like you don't have any additional time left on your H1, or you file an LCA by mistake only for 1 year, then they'll approve it only for 1 year.
Yeah, we have a caller, Sandeep from New York, I believe. Hi, Sandeep. Welcome to the show. You are on the air, and you can ask your question.
Yeah. Hi, Ranjit. Hi, madam.
Hi.
I have two questions. The first question is actually I'm on H1B, and my H1 is expired in 2022. So will I be? I'm actually in my earlier I had a H1B visa stamp of in 2017. Then after I changed my employer, and completely it's been more than 3 years that my H1 visa stamping expired. So will I be eligible to be for the Dropbox? I think recently, I think we had a news stating that if there is no change in if the visa is expired within last 2 years, then we are eligible for the Dropbox, right? So in my case, will I be eligible? Although it's 2 years, it's crossed 3 years. Will I be eligible for that?
Unfortunately, no. You already know what the law is, so you already know your answer. So there's no exceptions to that. If you're not within 2 years, as they said, then you're not eligible for Dropbox. You just have to go the regular route, and you will be called for an interview, I guess. But remember, even the Dropbox, as I was saying earlier, doesn't necessarily mean that you won't be called for an interview. USCIS still has the discretion to call you for an interview, even if you do a Dropbox. At some point, they were doing exactly that. They were saying Dropbox, but they were calling everybody for an interview. So yes, with response to your question, yes, you will not be eligible for the Dropbox.
Yeah, as we are not getting any appointments in the soon, so that's what I was wondering, if I will be eligible for at least for the visa Dropbox.
Right. No, I don't think so.
The next question I have. Okay. Yeah, thank you. And the next question is actually I had an I-140 with my earlier employer, with priority date of 2016 in EB2. So in 2019, last year, I think I moved to the end client, and they started the process recently, but they started filing in EB3. So the first question I have is, will the priority date of EB2 can be retained for EB3?
Yes, it can. It doesn't matter what the category is, the priority date can be retained.
Okay. And if I have to go, if my employer actually did not revoke the I-140, although it's been like 4 years, So if it is current, if the priority date is current, right? Can I back switch my to my old employer? Will that be an issue? Do we have any disadvantage or any risk in going there to the old employer?
So why would you want to go to the old employer? Because your new I-140 is
If
not
at all.
approved?
Yeah, my current company, the client just started the perm process.
Okay.
The labor
So
certification itself will
I
take
would
like
suggest
4 months.
file premium processing for whatever it's worth. But yes, if it doesn't get approved, then yes, you can switch to your old employer and ask them to file the 485 for you.
Okay, I think he got the answer. Okay, we were talking about what happens when so always the latest one will take over, and because of that you will lose the extension or whatever the validity you have. So last action will always take over. That's what it is, right?
Correct, yes. There's often confusion around this subject, and we get quite a lot of questions just on this last action. Oh, I filed this, then I filed this, then I filed a change of status. I want to do this. I want to file 2 applications at the same time because I want to make sure I don't lose status. Can I do it? I want to file a H4 and then a H1. So this is quite common because people are so anxious about their status that they often file multiple petitions and they're confused as to which one will actually be valid.
Yeah. Another question is, especially in these times of COVID, because of there is a lot of changes in the timelines, the project, and everything. So let's say if an amendment or something is pending, and there is another change, and you have to move. Especially this happens in the consulting business. So if they had to move to another company, can someone file an amendment already when an amendment is pending, or is there anything that you have to wait until the amendment is approved and only then file another amendment?
Right, and this situation also happens very, very often. So basically, while one petition is pending, you have to file another petition because your circumstances have changed. So this is called basically if your I-94 has expired during that time, then it's called a bridging petition. You're still allowed to file, though you don't have a valid I-94, because the previous petition was filed while your I-94 was pending. So then it becomes a bridging petition. And basically the bridging rule is that, if your previous petition was approvable when filed, meaning it doesn't have to be approved, but if it was approvable when filed, USCIS will make that determination, then your second petition can also be approved. That's because the bridge has been created and it's a valid petition that you filed. If they find that it was a frivolous petition, or then they might say that there is no bridge created or the bridge has been broken, and thereby you cannot file a second petition then until the previous petition is decided. So if the I-94 is valid still, then there's no issue. It's just last action rule that comes into play, and then you file a second petition, and obviously that second petition takes precedence over the earlier petition. So you can go with the second petition. If you don't want to go with the second petition, you need to withdraw it before it gets approved. Then that last action rule will not apply because it's been withdrawn before approval. It's a little complicated, I know, but hopefully everyone understood.
Yeah, yes. So always remember the last action will take over. So, and anytime, especially this happens in the consulting business, as well as especially in these unforeseen circumstances where because of COVID, a lot of projects roll out, or they plan to postpone it, and you end up amending many doing many amendments. So that's when this is kind of as long as your I-94 is valid, you are good. If not, then when you have filed the first one, if you had a valid I-94, then that should be considered.
Correct.
Yeah. And another question here we have offline is, what happens when there is an overlap, between an H-1B transfer? Overlap in the sense, I've already resigned my company. Let's assume, and I have 2 or 3 weeks of notice which I have to serve. Uh, I have I have already an H1B transfer that's waiting me to join, and they want me to join sooner. So let's say at some point of time there is an overlap, and you get paid from both employers for a week or so. This happens sometimes where they want you to join sooner and they want you to serve the notice period. So you end up working for both of them. So is that allowed? Can someone be paid for two employers at a time, at least for a
Very
period of
interesting
time?
question, actually. Yeah. So basically, we have to look at whether it's legal for you to work for the second employer, and it is, because you're filing a transfer. As soon as you file a transfer, you can work for another company. But I think unless it's a concurrent petition, you can't work for two employers at the same time. That is possible only if you have a concurrent petition. In this case, they're asking you to decide. If you're filing a transfer, you can only either choose to wait until the transfer is approved and then join, or you can join while the transfer is pending. But there is no purpose in having a concurrent petition then, if you are allowed to work for two employers in this situation. So I would say no. I would say don't do it. If you're not working, but you're getting a check from the old employer because it's severance pay, that is fine, because that is owed to you from the previous work that you did. But I think working at the same time for both, I don't know how they would find out, but if they did, then it's questionable, definitely. For sure, you try and avoid being in that situation. But I understand what you're saying, that it's very common.
Because this happens quite often. There would be at least couple of days overlap. I don't think it really
But how do you
matters,
actually work for both employers? Because how many hours do you have in a day? So you have to actually, it's like 80 hours. So you're pretty much working 80 hours, for both employers. Yeah,
yes,
I would avoid that
when it's
situation.
in COVID, or especially when it's remote. Anyways, we are at the end of the time. I think we have to wrap up. If you have to reach the attorney for a private consultation, please reach at 212-354-1010 or prashanti@reddyesq.com. If someone is expecting the date to become current, please be ready and get a consultation from the attorney and keep everything ready, and don't waste your time until last minute. Thanks for all the calls and watching the show. It was a great session with interesting topics and questions. Please call in every Wednesday at 6 p.m. EST to watch the Immigration Talk Show. Again, it's every Wednesday, 6 p.m. Eastern Time on Sakshi TV. This is Ranjit signing off. Thanks for sharing.